Service Board meeting to order, April 5th, 2017. A motion to adopt the agenda.
So moved.
Second.
Motion made and seconded to adopt the agenda. All in favor, say aye.
Aye.
Aye. Everybody had an opportunity to read the minutes.
Yeah.
Are there any corrections or additions that anybody would like to make to the minutes? Motion to approve the minutes.
So moved. Second.
All in favor of approving the minutes, say aye.
Aye.
Director's report.
If we could just take a brief moment to approve the agenda as well. Did we? I must have missed that. Did we already do that? Okay. I was focused on my iPad. Thanks. We'll just roll on then.
I did fail to request a reading of the formal notice.
Yes, sir. Notice of the April 5th, 2017 meeting of the Collection Service Board was posted to the Collection Service Board website on March 30th, 2017. Now for the director's report. What I'll do is I'll start with the month, since we've already covered the previous period in our last board meeting, and then we'll do the yearly, and then just kind of open it up for questions if you have any follow-ups, areas of concern. First of all, February, our revenue was actually in the red at 23,700. And which was our licensing revenue, for a total of 23,950 in the red. And then of course our expenses were 22,996, which left us in the red of 46,946. Now I did, before we began, I passed out some documentation to account for that. As you can see, if you look at the trend, we're tracking in the black all the way across the board, and then we hit this road bump here. So what happened was there was a refund due to one company misinterpreting the law, misunderstanding the requirements for solicitor cards, and as a result, they bought one for all of their employees rather than the folks that are actually soliciting. So that misinterpretation of the term solicitor was the cause for that. So there was a big refund that went out, and in excess of $43,000, accounting for that anomaly in our trending. But then if we move to the yearly, we have gross revenues of $230,140. Then we have expenses of $118,430, with a net surplus of $111,710. Was there any questions either about the refund or about the any expenses or any of those line items as well under collection revenues or collection expenses?
Not a question so much about that. You start with July and go to February, and then call it yearly, as opposed to year to date. Do we do a rolling 12 months, or is our fiscal year starting in July?
Yes, sir. That's correct.
Okay. So it's year to date.
I know that from time to time the state have they robbed us yet?
Well, you're probably talking about the Edison, where they schedule the expenditures in those. Looks like January. I haven't seen the schedule, but January does appear to be the big hit for Edison, or that scheduling. And of course that would be the licensing revenue, and the case revenue is of course the civil penalty and recovery. And one thing too, that state reg fee, that's we pay $5 per year per license and renewals to fiscal, and what F&A, what they do, it's a workaround for C&I, because we can't bill those fees directly, so F&A does that for us. So that's really a reduction in revenue is what that is. it's not so much an expense, but it's a workaround. So that's why you have that line item there as well.
Other questions about the director's report? If not, I'll entertain a motion, we accept it. Elizabeth, do you have a
I
question?
do have just one question, just looking at the size of this and what happened here. Do we anticipate that there's any other agencies, large agencies?
There was a couple others that we gave sizable refunds to. I don't have the documentation from me, but it's in excess of $3,000 on both of those as well, and it was a similar type misinterpretation. So that would also account for some of that in there. But obviously, the 43,000 was such a huge number. We wanted to make sure that you understood that was why you have such an anomaly in that trending.
They've been paying these in previous years? Are they trying to go back?
No, these were recent.
These are, okay. I know these are
Oh,
recent,
right.
but I didn't know once they
Yeah, did they
figured it out.
Had they paid it
that-
before and
Have they paid this before, and are they going to potentially,
this company's been around a long time.
Yeah.
Yeah, Midland would be in Tennessee for a long time.
right?
If I may, I'd like to defer to some of the support staff that works on a regular basis that can kind of give us a historical reference and time frame on that. Dennis, did you have anything else you could add? Or
Actually, this was the first time they made this mistake because we panicked when I saw $43,000 refund. We went back and found the other renewals. They had never paid it. I don't know what got into them this time around.
That's what I was just
We
wondering.
didn't
I
panic when
understood
we
the
got
question.
check.
Yeah, they'd never done it before. So when we saw such a huge amount, we actually alerted them and said, "Have you really taken on this many people?" And they were like, "No." So we said, "I think you misinterpreted this. We didn't want to hold on to the money and then later on realize we really, in good alerted them that they had made a
I'm
mistake."
glad we found it.
We actually
With
did
that,
so.
it's fine, good.
Thank you.
thank you, Dennis.
So I'll make a motion that we accept.
Is there a second?
report.
Second.
All in favor of accepting the director's report, say aye.
Aye.
Budget report, oh, that's the director's report, sorry. Legal report.
All right, I've got the first few cases on this legal. Number one is 2016-002. This case arises out of a consumer complaint alleging a medical provider did a debt to collections. Complainant visited a medical When his insurer did not pay, the provider placed the debt for collection with respondent sent complainant an initial notice letter. Complainant keeps going off. Complainant forwarded the initial notice letter to his insurer.
Yes, we can hear you, but I'm not sure you're getting recorded, but.
All right. Okay. Complainant forwarded the initial notice letter to his insurer. The insurer paid the complainant claims that the alleged debt still appears on his credit history. Respondent states that their only contact with complainant was the initial notice letter. Upon receiving a copy of the complaint, respondent closed complainant's account. Respondent also submitted a request to delete the debt from complainant's credit history. Counsel recommends that this matter be dismissed.
Thank you, Lindsay. I think what we'd like to do is if you would just read each one of them into the record as they are, and then we'll take our time to read them and then have comments after.
ID number only.
But-
Only the number, not the.
Just the number is what.
I'm sorry, yeah, just the reference number.
There are a couple typos that I wanted to bring your attention to.
Okay.
On case number 2017006381, in the second to last line, that should be 43%, not 48%. And then I think my co-counsel may have found a couple.
Cases that I have, which begin with number 16. I have a couple of corrections as well. In the first paragraph, the third sentence, It's case number 2017-002511. The third sentence should read, "The complainant alleges the respondent contacted the home warranty company." Then a little further down in that paragraph, there's a sentence that begins, "A supervisor did not call back for weeks, and the complainant no longer wanted to do business with the company." The word inserted before business. Then on the next one, number 17, that's case number 2017-009361. Towards the bottom of the second paragraph, the sentence that begins with, "The complainant stated that her son has not lived with them for 9 years." Them, the word them should be inserted before for. In the next one, number 18, 2017-008531, in the first sentence, towards the end after the date, January 9th, 2017, comma, however, the invoice was dated on January 18th. On should be struck from that portion of the sentence, and it should just read, "The invoice was dated January 18th, 2017. In number 19, 2017-003881, in the recommendation section of this complaint, after where it says 30 days of execution of the consent order, it should be period. The rest of that sentence should be struck. Then in number 23, 2017-002961, in the first paragraph, towards the bottom of that paragraph where the sentence begins, "Also, the respondent attorney stated to the complainant the lien would remain on the home and the complainant had to sign a new agreement, period." Had to be signed should be struck from the rest of that sentence. Number 24, 2017-004231, towards the bottom of that paragraph with the sentence beginning, "Additionally, the used car dealer has demanded payment for the arrears and damage to the vehicle and has refused to release the car to the complainant after he stated he would resume." The word "he" should be inserted before "stated." Number 26 is a duplicate. It should be completely struck. It's the same one as number 21. And I believe that's all, and I'd just like to apologize for all of these errors. We were in a little bit of a time crunch to get this finalized, and I will be sure to make sure the next time that this doesn't happen to this extent. Thank you.
Do you want me to go ahead and read case numbers into the record?
Just a moment. Yes, we will when we get to it. I'm looking for 21. I got
21 is on page 12.
okay. And we deleted 26. It's the same.
Yes, sir.
Excellent job, by the way. Well put together. A couple of typos, but those things can happen. But it's very informative. And Lindsay, please read the numbers in to the record, and then we will we'll review them ourselves.
Sure. Number 1 is 2016-07218. Number 2 is 2017-0060. 6381. Number 3 is 2016-073571. Number 4 is 2016-075131. Number 5 is 2017-002381. Number 6 is 2017-000951. Number 7 is 2017-000871. Case number 8 is 2017-002591. Case number 9 is 2017-008521. Case number 10 is 2017-006101. Case number 11 is 2017-006731. Case number 12 is 2017-007671. Case number 13 is 2017-006811. Case number 14 is 2017-012421. Case number 15 is 2017-012301. Case number 16 is 2017-002511. Case number 17 is 2017-009361. Case number 18 is 2017-008531. Case number 19 is 2017-003881. Case number 20 is 2017-005081. Case number 21 is 2017-006481. Case number 22 is 2017-002751. Case number 23 is 2017-002961. Case number 24 is 2017-004231. Case number 25 is 2017-008931. Case number 6 was stricken as it was a duplicate. Case number 27, 2017-011201. Case number 28, 2016-072261. Case number 29 is 2015-007381. Case number 30 is 2016-064091. And case number 31 is 2016-075641. And that concludes the cases on this legal report.
Thank you. Does any of the members want to take a few moments and review each one of these? Let's, if we can, go to each one of them just by the number 1, 2, 3, and 4, and solicit any questions or comments. One? No comments? Let's say the recommendation from the council is approved. Okay, recommendation from the council approved on number 1. Number 2.
Percentage of 43, obviously 48's a typo. $1,000.
That's what they told our investigator, but a printout from their internal records shows that it was not. Someone had handwritten the principal amount and then added a 43% fee.
Fee's a little high, but there is no stipulation as to the fee amount. Other places we've done 28 and 25, that percent fee. Are we saying the fee is out of line? Or?
No, it has to do with how it was represented to the client and how the respondent's statements to the investigator. One of respondent's representatives told the investigator that they only collect a 28% fee, even though that's clearly not the case. So that would be a violation of Rule 0320-02-.02, misrepresenting the terms of its listing contract or the commission chargeable thereunder. Another issue is if we wanted to pursue this, when they sent the initial notice letter, they went ahead and added the 43% fee and stated that the entire amount was due to the creditor. Under federal law, that would be a violation of 15 USC Section 192 E2A. Debt collector may not use any false, deceptive, or misleading representation or means in connection with the collection of any debt. Without limiting the general application of the foregoing, the following conduct is a violation of this section. Number 2, the false representation of A, the character, amount, or legal status of any debt. The respondent characterized the 28% fee as a contingency fee. And if it's a contingency fee, they aren't able to collect that until the respondent has actually paid. So by going ahead and including any fee within the initial notice letter and not specifically identifying that a portion of that fee was actually due to the collection agency, not the creditor, would be a violation.
Let's assume somebody's collecting a check, and the check fee is collection agency sends out a notice for the $25 check, a violation of the federal law?
Not if you differentiate
Separately?
right,
Okay.
those two items.
So the complaint is not for the amount of the fee, it's the fact that they requested the whole thing instead of distinguishing between the original debt and the fee for collecting the debt.
That would be a violation under federal law. We could go after them for that as well. The specific statute that I cited, I stated state law, which our code states that any violation of federal law is also a violation of the board's rules and standards. So the state rule and regulation that I cited is for misrepresenting the terms of the contract to our investigator. Correct. Yes.
Did the complainant pay the creditor or pay the agency any money at all? Or does it, I know it doesn't really matter. I'm curious to see if the creditor refunded the responder.
I'm not sure.
Simply that the fee was added to the
Right, so that's another issue. Under federal law, so I requested a copy of the contract when I sent this for investigation, the underlying contract between the creditor, which was the medical provider, and the debtor, who's the complainant. And that contract had language in there which the complainant signed stating, in the event my account is placed with an outside collection agency for collection, I agree to pay all collection costs, court, and attorney's fees incurred to collect my account. So they're allowed to collect a fee. They just can't misrepresent it in the initial notice letter.
So that was in the initial notice letter?
Yes, sir.
The increased amount was in the initial notice?
Yes.
Oh, okay.
So they just
That's even worse. That is even worse.
Right. So the principal debt amount was $459.75. The respondent went ahead and tacked on a 43% fee and sent an initial notice letter just stating that they owed $657.44 to the creditor.
Say they owed that including fees? Did they indicate that it included fees in the letter?
No, they did not.
That's what they did wrong.
Yeah.
They said you owe the doctor $700, and actually they didn't owe the doctor $700, they owed the doctor $500 and the collection agency $200.
Let me just review this initial notice letter real fast because I want to confirm. No, it states that the entire amount is due. It does not indicate that there are any fees. It actually indicates that the entire $657.44 is past due, which is a mischaracterization because, right.
Why 1,000? Just curious. How did it weigh out at that? Bad number, by the way.
Well, $1,000 is the maximum civil penalty for that specific violation. As I said, there are additional violations under federal law, which we could go after them for, but that's how I came to the maximum civil penalty amount for the single violation that I cited.
I'm okay with your recommendation, it's fine. I wonder if we should mention in our letter that if they have collected this fee in error, well, they haven't collected it in error, I guess. They could keep the money.
I'm not really sure about like whether they could keep it or not. I think it's more just the fact that they mischaracterized it.
Thinking about the consumer,
Oh, right.
whether we should request, suggest, or demand that the agency repay the consumer this exorbitant fee.
We don't know it was collected.
I know.
Do we know that it was? That wasn't the complaint.
I know.
Yeah, so they probably didn't pay it if they knew.
And that's not within the scope of our authority. We can include when we send out, if you authorize settlement of $1,000 and I send a consent order, I can include cease and desist language stating that they will not include contingent of fees not yet earned in future debt collection activity.
Not included. They can identify that it's there, and they probably should, but they shouldn't add them together. Yeah, I agree.
Everybody okay with that?
Yes.
Number 3? That traditionally we've charged a $250 fine for bond, even though this respondent responded to the board's investigator. We shouldn't have to send out an investigator.
Okay, we can
Is that
change
okay
that.
with the rest of the board?
Yes.
Okay.
Just to be clear, a $250 civil penalty with formal charges authorized if they don't pay.
Yes.
But it would be a warning with the penalty, and if they don't pay, then it goes to.
It would be a consent order that they would have to sign and send a check to, and if they choose not to sign that consent order, then we would take them to trial.
Number 4, the only thing that I have to comment about this, I don't think there's a problem necessarily, but they've been in business for 13 years and they're just now realizing that they're reporting their trust obligations. Five. Number 6.
On number 6, cent fee do we consider okay? Do we have any 30, there's a 28?
Like I said, it's not really about the amount of the fee. I mean, whether that fee amount is unconscionable would be more of a civil lawsuit matter.
So are you saying we don't have oversight over how much fees are being charged? Because that seems like some of these fees are really outrageous to me.
Depends on if it's been placed for legal. There's step fees. Mid-20 fee is not outrageous. That's 33% is still not crazy.
I don't think our statute speaks to the amount of a collection fee that does speak to the fact that it's got to be contracted for. And years ago, the federal government suggested that we put the amount of the charge you a 50% fee to collect the debt. And if it's not in there, then it's pretty much whatever anybody seems reasonable. For the law, a judge would throw it out, of course. But I don't know authority to regulate the amount of a collection fee.
In which that is allowed, or where we can regulate the collection fees, as I think you're getting at the post-judgment interest rate. But when there's no trial in civil judgment, that's correct.
Like somebody writes the convenience store a $5 check and it bounces and they charge $30 for a recovery fee. That's usurious too, in my opinion.
Not the amount of the check, it's the fact of the check. So a $25 fee for a check, if it had been a $1,000 check, the fee would still be $25 because it's for a check, not.
It'd be treble damages, up to $1,000. $500 for writing a bad check, treble damages. I think that that's something we should probably look at. I don't know that we have the authority to do that on this amounts of fee. Six. Oh, that was 6. Number 7. Number 8. Number 9. 11, 12, 13, 14, 15, I think once again that failure to respond should be a
Civil penalty.
civil penalty.
$250?
Yes, sir.
Okay.
If that's
Same-
okay.
same 250?
Yes, ma'am. Yes, sir. Number 15. 16. We've discussed that. Everybody okay with that one? Number 17. 18. 19. Okay. 20. 21.
The only question I have about 21 is, I know we've gotten into this before about trying to, on unlicensed agencies. And them cease and desist. That was just my question.
I've had that question myself. Send them I guess we could send them a civil penalty for $500.
One, since they were licensed at one time and they didn't relicense and collect, we probably have grounds under their license for not renewing it and continuing to collect because somebody was never licensed. I agree with you.
Good point.
But because they were previously licensed,
I missed that. Where is it?
no, we're on 20, right?
21.
21.
Oh, okay. I'm sorry. I was looking at 20.
Are you questioning whether we can go after unlicensed persons?
I think the question was, do we have the authority to send them a bill for $500?
Fairly certain that all boards can go after people. You have the authority to go after people who are doing things that are defined in your statute as requiring a license. That's been pretty broadly interpreted.
What would be our remedy?
What you couldn't do is go after an unlicensed person for violating your statute, but you could go after them. Like, you couldn't go after them because they collected a fee they weren't allowed to collect. You could only go after them for
What would we do if they didn't pay the
We take them to trial.
Years ago, there was an agency in Brentwood, I think, kept collecting, for years. He just failed to even do anything. We sent an investigator out there and the whole thing, and that kept collecting debts. And I don't think we ever got any money out of him, but we finally did get him to quit collecting. Remember him?
Yeah, we've never had a lot of luck that I know of collecting these civil penalties from people that were unlicensed because they kind of already defying the situation.
Even if Lindsay ended up taking them to trial and she got a default judgment because they didn't even show up, we have our own collections agencies. So when people don't pay fines that they're required, we also use collection agencies. Yes.
Oh, good for you.
These mics.
With 21?
Yep.
22? 23? 24? 5? $500 civil penalty. Failure to respond, but why is it $500 and not $250 and some
Well, they're
other
also
ones?
unlicensed. Yeah, that was.
Yeah. So it's $250 for failing to respond and $250 for unlicensed?
Yes, sir.
the 21 respondents,
Okay.
5
Didn't,
did not respond. Are unlicensed.
should all these also be getting a cease and desist?
Yeah.
Or are they getting cease and desist as well?
Yes, typically in the consent order, that language is included to cease and most of the time in the cover letters too, they're advised to cease and desist.
26, to cross out, yeah. 27, 28, 9, 30, 'em. Worry about people like this. I don't know how a credit bureau will accept a collection aid, without it being a licensed collector. I don't know. 31,
Well, and 31's kind of that, and then also, I know we've had discussions about this before as to whether or not listing against a credit, someone's credit.
I think there's been I think there's been a federal opinion that it does not.
Does not.
Just simply.
I just remember some discussion around that in the past, and,
This is the purchase debt company. Corresponded with the debtor, then they attempted to collect.
Right.
They shouldn't have even answered the question.
And they got to send a validation notice and all of that.
Yeah.
If they talk to them.
Face it, it's fine for them to buy the debt. Not okay for them to respond with anything other than I can't respond, you've got to contact this. I would think if an unlicensed debt buyer discusses the debt with the debtor, they're attempting to collect it. Am I too far out?
well,
No,
it goes to what you were saying too about even being able to list it. It seems that,
You can send it to the bureau. You're not touching the debtor by. There's been some question about is serving somebody without being licensed. You've reached out and touched them, and service itself is also a contact. Typically, service would have been done by the agency, but it's by a law firm, but it's done on behalf of the debt buyer, so it's done on the debt buyer's. Says he spoke with them about it and informed them they have to pay the debt to get it removed.
yes, sir, that's correct.
The debt buyer had conversations with the debtor. Is that what that implies, or do we know
Yes,
that
sir.
for a fact?
They had contact with the debtor.
I think they attempted to collect, and I think and these people had a license at one time, and they felt like, heck, let's just not buy a license. And they're on a slippery slope. These debt buyers that don't get a collection license are on a slippery slope, particularly if they report them to the credit bureau, because there's going to be a contact made.
But if you only say, contact my law firm, I can't discuss it with you, you're okay, I think. But if you say you've got to pay the debt, you just attempted to collect the debt.
Yes. So would $1,000 fine be more appropriate because they're not licensed and they attempted to collect the debt as without a license? Or is that the same thing?
Well, it's kind of one and the same, but you can assess the maximum of 1,000.
Yes.
Okay.
Oh, it does say expired license. Yeah, if they had the license at one time, they should know better.
Yeah. Okay, that's it for the 31. I would entertain a motion that we accept the legal report with changes as made and with corrections in the type errors.
So moved.
Second.
All in favor say aye.
Aye.
Okay. Application review. That is irritating, isn't it? What, specifically, what were we looking at with this application?
I believe it's just a general review. They're wanting to. It's a new application. Iman, did you have anything that you want to add in particular?
Yes, actually, they check the box for, and the answer yes, that they have a civil penalty or civil suit or action pending against this company, and they sent kind of explanations, and we need your opinion and your.
Because of the legal actions that's been brought against them. Also, no, they're out of trust. Well, but if you read a little deeper into the question, or we're not answering the question, we're not asking the question correctly on our application. If we said in our application, a trust account, if it said trust held for clients, when they say trust, in their mind, it's like a family trust or something. Did you see that?
Yeah.
It's not. I don't think that that's the. This should read trust amount held in trust for clients. I guess would be a better question. I reviewed these lawsuits against the company, and 1, 2, 3. The fifth one down is a lawsuit filed by apparently a consumer against this agency, Tennessee. And if they weren't doing collections in Tennessee, how in the world would they have and the lawsuit is regarding a Fair Debt Collection Practices Act response. Did you see that?
I read it actually, but yeah, you're right.
Yes, sir.
On the trust account, on the financial, they have restricted.
I want to say something about this one. The state auditor actually reviewed their trust account and their financial statement, and he approved it after he got the explanations from them, and everything for statement, a financial statement is our auditor, by the state auditor.
They threw the trust account down in other assets, not in cash, which is goofy, but they had it pretty well identified in the statement.
Question this lawsuit that was filed by a consumer in Tennessee for a violation of Fair Debt Collection Practices Act, and that would indicate that they were doing collection work here in the state. So I think that wouldn't you? So I think that we should send them a letter. And I have one other thing too. they presented a bond for $20,000, and they have 660 employees, so they need a $25,000 bond.
I fixed this one too because I requested one for 25,000. Yes, sir.
I'd like to send them a letter and ask them to explain this lawsuit in Tennessee, and ask them if they were since they were doing collection effort, since they got sued in Tennessee by a consumer, they must have been doing some collection effort.
Ask for some more details of that lawsuit.
As for that balance sheet, you feel like there should be more clarification on that part as well then?
Well, this is a huge, huge company. I know this company, and they are a huge company. And when it's publicly traded or it's as involved as this company is with billions of dollars, this question on our form should read trust account, money held in trust for the clients, some way of saying that.
Restricted cash is.
Restricted cash
It
is.
says restricted
is that.
cash. They just misclassified it.
I think we're okay, Glenn. It's just unusual to have a company this big.
Here's the follow-up information on the suit that they have. I'm afraid I'm not seeing it to understand.
Yeah, here.
And do we have any information about what happened with the motion for summary judgment? Okay.
Follow up on that since that was due in March.
Okay. On this wrongful repossession, a repossession doesn't mean it's a contact. Repo agency get it, and they've never attempted to collect. Says that single plaintiff lawsuit by alleging wrong. Repo, that's probably I don't think they were doing what they might be doing.
I'm not sure that they were, but I think with more clarification, and it also says complaint sets forth causes of action for violation of Fair Debt Collection Practices Act, violation of Consumer Protection Act, and so forth. Well, yeah.
Okay. I do want to clarify, if an out-of-state agency has somebody
I think not.
No, I think the repo agency has.
The Form Commercial Code authorizes them to go get the car if there's no violence. And hiring a collection agency or a repo agency, if the repo agency guys to go out and say, we need your money or your car, then yeah, they're trying to collect the debt, but I doubt that that's what an agency.
Well, they don't talk.
Sorry.
Well, 9 times out of 10, there's a deficiency balance, and
Efficiency balance comes after the repo. Yeah, I'm glad to have this company in Tennessee. They're a good company. Any new business?
So now we're gonna send them letter for more information, correct?
I beg your pardon?
We're gonna send this company letter, ask for more information, correct, sir?
at this specific
Okay.
lawsuit.
And we should maybe mention to them our concern about the way they answered that trust question. And that even just to tell them that trust question on our application is the money that they're held in trust for their clients.
So we'll definitely articulate that in our correspondence to them as well. There was a couple other actions that are, I guess, new business items that I think legal wanted to touch on, and
Okay.
as well as when we get to that point is.
Okay. I think we're through with the legal report, and we've reviewed the application. Do we need a motion for the review of the application?
I don't think so. We were just trying to get it up for discussion and get some clarity on a path forward. Thank you, sir.
And you have asked them for a $25,000 bond.
Okay, if you're ready for new business. About a class action lawsuit that was settled. U.S. Code requires that when a class action lawsuit is settled, if all of the organizations that license that person be contacted. The defendant in the class action lawsuit does hold, I think, 5 licenses for collections here in Tennessee. I wanted to report this to you so that we could talk about what you wanted to do moving forward. The lawsuit that was filed against the defendants asserted that they violated state and federal law by initiating garnishments in Michigan for judgment debtors in which defendants basically saying that they had gone after debts that they were not owed and that they were incorrectly collecting on. And that class action lawsuit has settled. The defendants haven't obviously admitted to any wrongdoing in the settlement, but they are making payments out to the class members. It doesn't appear to me that this was happening anywhere outside of Michigan, but they are licensed by this board, so we're required to be updated on it. And I wanted to know if that's the kind of thing you want us to open complaints on and investigate and do our own internal investigation, or do you only want us to consider actions happening in Tennessee?
I would think just Tennessee.
Okay.
I mean,
I
if
just
they're
didn't know
if
if
they're
you want
okay
us to-
here, then
yeah.
you know,
As far as I'm aware, yes, they are okay here. They haven't done anything specifically in Tennessee, so that's why we haven't opened any complaints. But we can, if that's what you guys wanted. But I would suggest that if you're fine with only considering the Tennessee residents, then we're fine to just keep this in our records and move forward.
Were they attempting to garnish people that there was no judgment?
Yes.
You might want to put a little flag on there.
Okay.
Are there any complaint, is there a complaint history on them? How long have they been licensed here?
I actually don't know if there's a complaint history on them. I don't think anything alarming. They
They're not a law firm.
I
And
can
it-
double check the complaint history to make sure it doesn't match up with this, and then talk about it again, just because I don't have it in front of me. But if I remember correctly, when we were looking into this, it didn't seem as if there had been huge problems here in Tennessee. Okay.
No more new business?
A question, sir, if you don't mind. Should the application, back to the application, wait until the next meeting for you to review their answer, or should send it to you by email, or what do you recommend?
I think that that legal could review it, and if they feel it's okay, then it'll be all right. If that's the consensus of the board.
agreed.
Yeah, I'm fine with that.
No other business, we will adjourn the meeting.
I'll make that motion.
Second.
I know Barney's get away from that screaming.